Hi, I'm John Hayes. I'm a certified bankruptcy specialist in California, Southern California. I am a partner in the firm of Resnick Hayes Girardi. And I also am a professor, adjunct professor at the University of West Los Angeles Law School, where I've taught for 30 years now. This semester, I'm teaching the basic bankruptcy class. This semester being spring of 2021. So I'm doing these videos now a little bit more in depth for the benefit of my students. But also, I think new lawyers, certainly new bankruptcy lawyers, and other lawyers would be interested in what I'm going to discuss today. And that is this concept of involuntary bankruptcy and how it's playing out in the case of Tom Girardi. So let's start by talking about involuntary bankruptcy. I assume almost everybody who hears this, other than those who know about involuntary bankruptcy, will be shocked to find out that it's very easy to start an involuntary bankruptcy case. I mean, I know the name of my neighbor. I could put him into an involuntary bankruptcy within 20 minutes. It's a 3-page form, and all it asks is what's his name. It says, what's his social security, if you know. Well, I don't know. I know his address, though. Check a couple boxes and upload it. If you can't upload it, take it to the bankruptcy court. This is Sunday, they're not open today. Go in tomorrow morning. You hand the form to the clerk. My neighbor is in bankruptcy. Sort of. There are some, with involuntary, it's a little weird, and that's what I'm going to talk about. So that's could lead to some mischievous things, you would think, if I'll put my enemy, some enemy. So what about, the opposing party or clients that I'm trying to get paid from? Or if it's so easy, it's actually, you would think, surprising that it hardly ever happens. So why is that? Why is it so easy and yet it hardly ever happens? The reason is to put somebody in bankruptcy. What I've been talking about is the form, very easy form. The basis for keeping somebody in bankruptcy, there's only 2 parts. And they're very simple parts. And I'm going to talk about those at some length. The person who puts somebody in the involuntary bankruptcy is called a petitioning creditor. So in my example, my neighbor would be the alleged debtor, sometimes called the punitive debtor. I would be called the petitioning creditor. I, as the petitioning creditor, have to establish, after I file the forms, I have to establish 2 things. If I establish those, the bankruptcy proceeds as any other bankruptcy would. If I'm wrong, and I can't prove those 2 things, damages against me personally are basically mandatory. And that includes attorney's fees and punitive damages in an appropriate case. If you're going to put somebody into bankruptcy, you better be right, because that's a big deal. And if you're wrong, you have to pay actual damages plus attorney's fees plus punitive damages. I've filed a couple. I've defended several. I've defended two that turned out to be wars. Be careful. All right, so what are the two things? The first thing is the creditor, me in my example, there has to be a debt. He has to owe me money. And it has to be undisputed. So if I loaned him money at $10,000, he owes me $10,000. Well, if he thinks he only owes me $5,000, the debt is disputed. I can't be a petitioning creditor if the debt is disputed, even in part. The Ninth Circuit Court of Appeals just in the last couple of years confirmed that in a case called Blixith, Blixeth. They said the Ninth Circuit said if some of the debt is disputed and some of it isn't, for involuntary petition purposes, it's disputed. You can't be a petitioning creditor. Secondly, if the debtor, the alleged debtor, the person that's getting thrown into bankruptcy, has more than 12 creditors, there has to be 3 petitioning creditors. And each one of them are going to get whacked if they turn out to be wrong. But the petitioning creditor, first of all, the amount owed has to be more than $17,000, I think, roughly. So in my example, the guy only owed me 10. I can't be the petitioning creditor even if it's undisputed. So the total debt owed to the petitioning creditors has to be more than some number. It's around $17,000, $18,000. All right. If there's a reasonable belief that the debtor has more than 12 creditors, then you need 3 petitioning creditors. And each have to have an undisputed claim against the debtor. That's part 1. Part 2 is the debtor has to be, this is the most critical part of the whole analysis. The debtor must be, quote, generally not paying his debts as they come due. Doesn't matter if he's insolvent, doesn't matter if he's hiding property, doesn't matter if he's a horrible person. He must be generally not paying his debts as they come due. There's one other, there's an or to that. Generally paying your debts as they become due, or. The or almost never comes up. And the or is if the debtor transferred his property to like a receiver or asked an assignment for the benefit of creditors, something like that. So the debtor has to be generally not paying his debts as they become due. So the way it works is, but before I start on the way it works, I have to tell you that those are 2 facts. That I have an undisputed debt against this guy of more than $17,000. What if he doesn't agree? Well, the judge has to make a finding of the fact. Either he owes me and it's undisputed and it's more than $17,000, or it isn't. So if he starts saying, well, actually, I paid him some of it, he told me I wouldn't have to pay, the statute of limitations is run. The court is going to have to hold an evidentiary hearing, similar to a trial. You're gonna have to get witnesses up on the stand and people testify and documents. And as lawyers know when you're gonna do that, that brings up this idea of discovery, you know. I want to see your documents, you want to see my documents. It's litigation is the point, all right? So here's how it works. The form, you upload this form called an involuntary petition, and the court then issues a summons. The summons has to be served on the alleged debtor, and the alleged debtor has some amount of time, I think 20 days or so, to answer, to file an answer to the involuntary summons. The court then sets a status that what's the answer going to be? It's disputed, I don't owe him anything, and I'm generally paying my debts as they become due. That's the answer. Judge dismissed this case because the two parts haven't been met. And the court sets a status conference and the court says, all right, well, when do you want to have trial over these two parts, all right? So how does that, that's what I was saying. Serve the petition, the involuntary petition. The debtor has, the alleged debtor has a certain amount of time to answer. And the debtor can file a motion to dismiss. That would only be granted though if there are no facts in dispute. I don't know how it could ever be. There's no issue as to whether I'm generally paying my debts as they become due. I mean, that's a factual mess. There might be an issue about whether the petitioning creditors are disputed and whether there's enough of them, whether the amount is high enough. And I suppose the answer by the debtor could say, I don't owe this guy anything. If that's true, the petition has to be dismissed. The case has to be dismissed. I want to say one more thing before I get in a little bit more to the trial, is when the involuntary petition is filed, a bankruptcy is started. But there's no order for relief. That's sort of magic words in the bankruptcy world. There's no order for relief. So it's sort of an official case. You know, all the stuff in the bankruptcy code applies when the order for relief is entered. So when the involuntary petition is uploaded, there's no order for relief yet. The bankruptcy judge has to make a finding that we have the right creditors and the debtor is generally not paying his debts as they become due, okay? But when the involuntary petition is uploaded, the automatic stay goes into effect. All creditors, as of the moment of the petition, must stop trying to collect their debts. All creditors must stop trying to collect their debts. And there's an estate consisting of all of the debtor's assets. All right, there's no trustee. And the debtor is allowed to keep operating their business and keep, get on with your life. But there is this estate and there's an automatic stay. All right, so the debtor is served with the involuntary petition. The debtor, let's say, files a response. I don't owe this guy as much as he says I do. I don't owe him anything. I have more than 12 creditors, therefore there has to be 3. There isn't enough. And by the way, I'm generally paying my debts as they become due. But the judge, as I've said, what the judge will do is set a trial. And the 2 I mentioned were wars. Trial is a year later, if you can believe that. you know, at least months and months and months to, you know, there's going to be an evidentiary hearing, a trial over these two issues. And the parties are allowed to do discovery. I can ask the debtor for documents. The debtor can ask me for documents. I can take his deposition. I can take his creditor's depositions. Eventually, the court will say, all right, call your first witness. The judge will listen, and then the judge will make a ruling. And he will say, I find that there's enough creditors, that they have undisputed claims of more than $17,000. And I find that the debtor is not generally paying his debts as they become due. And therefore, I'm going to enter an order for relief, which starts a bankruptcy. A trustee is appointed. The trustee proceeds on as if it was a voluntary case, all right? At the end of the trial, the judge might say, I don't think, Hayes, Mr. Petitioning Creditor, I don't think you've established that this guy is not generally paying his debts as they become due. Therefore, case dismissed. And the judge will say, I'm reserving jurisdiction to figure out how much the debtor's damages are and how much is attorney's fees and whether or not I should award punitive damages, which is going to turn out to be another trial, you know. The debtor then will file a motion for damages, a motion for attorney's fees, and you know, the creditor will say, he wasn't damaged. And anyway, you know, I'm a nice guy. I shouldn't have to be beat up like this. Big problem. Big boy, you better be right if you're going to be a petitioning creditor. All right, so what's all that have to do with Tom Girardi? Tom Girardi is like one of the biggest, most famous personal injury attorneys of my lifetime. I took him, I took a case that he taught at Loyola Law School in the 70s. It was called medical malpractice law. Guy's fascinating. I've sort of followed his career. But when our class, we had the class at Loyola, he invited the whole class to his office. And it was a big party. You know, he had a lot of people there, and boy, it was a lot of fun. I've heard him speak other times also, and I've just generally admired the guy big time. So when, you know, reading what's in the paper, you know, is he, you think he's generally paying his debts as they become due, he personally? The creditors who filed, the petitioning creditors, I think there's like 5 or 6 of them. They have judgments, I believe. A judgment is, some judge said, this is the amount you owe. There's no dispute if there's a judgment. Usually, there actually might still be a dispute if it's being appealed or something. But so there was also an involuntary petition filed against this partnership called Girardi and Keese. It is also now a debtor and in a bankruptcy case. The 2 petitions that were filed, the court asked for, I mean, the petitioning creditors asked that it be a Chapter 7. That the petitioning creditors could ask that the case be a Chapter 11. The thing about that is, if it is a Chapter 11, then the debtor is in charge of his case. So anyway, the Girardi and the Girardi and Keese cases were both Chapter 7s. The petition was filed in the latter part of December. And I was just looking at the docket this morning. It's February 21st today, 2021. The judge, not long after the involuntary petition was filed, the petitioning creditors asked the judge to appoint a trustee, even though there's no order for relief. And what they do is go in and say, Judge, you know, property's disappearing and this guy is a bad guy and he's making deals, and you know, Tom Girardi had the right to oppose that. He didn't. He didn't oppose the involuntary petition. And the bankruptcy court granted the motion for an interim trustee, it's called. And in mid-January, more or less, the bankruptcy judge entered an order for relief. So at that point, Tom Girardi is in Chapter 7. The trustee is going to seize all of his property and sell it as long as there's equity, and the property is not exempt. I mean, Tom can claim exemptions. The trustee is going to sell it. So the trustee in Tom's personal case, his name is Jason Rund. Very good guy, very good trustee. And, you know, the first thing he eyeballed was Tom Girardi's house in Pasadena. And, you know, he's going to sell the house. I didn't read it carefully enough to know whether or not there's equity in the house, but there must be. He's going to try to sell the house. On the corporation, Girardi and Keese, the trustee's name is Alyssa Miller. She's excellent trustee, excellent person. Her job is there's no such thing as an exemption in a non-individual case. So her job is to seize the property that belongs to the partnership, Girardi and Keese. And she can actually go after the partners also, although that appears to be, there's some question of whether Girardi and Keese had partners or not. You know, I think the world assumed they did. But a trustee of a partnership, Chapter 7, can go after partners for enough money to pay the debts of the partnership. So the order for relief has been entered on the corporate case also, and there's only been a little bit of litigation. Tom Girardi's a family member filed a request from the bankruptcy court to allow the family member to function as a custodian, basically saying that Tom Girardi is not competent to do what a debtor is supposed to do in a Chapter 7. And the bankruptcy court denied that motion, saying that it was moot because by then the state court had already said this particular individual can be the conservator of Tom Girardi and therefore can function as if he was the debtor. So we'll see what happens. Who else? What else the trustees are going to do? And you know, if you like this video I've done, click like. Okay, that's important to YouTube. If you have any questions, put your questions in the comments. This is something that's fun to discuss. I'm dying to see what the attorney for the petitioning creditors in the individual case and in the corporate case, the partnership case, is the same guy. I'm not sure if the petitioning creditors are the same, but he hasn't filed his fee application. I'm interested to see how much he's going to ask in attorney's fees, but they'll be allowed. But a reasonable amount of attorney's fees to the attorney for the petitioning creditors will be allowed, and the trustees will pay those fees. There's a priority about who gets paid first. We'll see what happens. Thank you. Send me, put your questions into the comments and I'll try to respond. Thanks.